A former Air Force major is calling for a review of his case after he was convicted at court-martial of sexually assaulting his wife. The ruling ended his career and resulted in a 42-week sentence in a military prison. One America's Neil W. McCabe spoke with him about the issue of due process and has this report.
Former Air Force Major Clarence Anderson is suing the acting Secretary of the Air Force and 2 Air Force generals in federal court here in Washington for what he says was a botched court-martial process.
I was a squad commander. She was actually a school teacher. And so when I learned about the affair that she was having, and this is when it was almost immediately she contacted base officials and then told them that the allegations against me that I sexually assaulted her while we were married.
Anderson, a veteran of 5 overseas deployments, including 2 to Afghanistan, said he was not arrested and he went about his duties as the process moved forward.
I did not think that it would go anywhere. I mean, there was no evidence that I ever committed a crime. There was no DNA evidence.
Anderson said he was so confident of vindication, he declined a jury trial and opted for a single judge to hear and decide his case. But at the time, he did not know that the Air Force Judge Advocate General, Lieutenant General Richard Harding, had ordered the Air Force's legal professionals to give extra weight to accusers and that all accusations must go to trial. Andrew Cherkasky, Anderson's attorney, told One American News, "It is very unusual for a conviction on such a serious charge on so little evidence."
It doesn't make a whole lot of sense when you walk into a case and you see no other corroborating evidence, no physical evidence, no DNA evidence, no eyewitness evidence, but it happened.
Cherkasky said it was only after the trial that Anderson's mother recorded a conversation with the ex-wife's boyfriend, where he told her he received $100,000 from Anderson's then mother-in-law.
After trial, it came out that there was potentially perjury that had occurred during the court-martial itself. Specifically, his ex-wife's new boyfriend, it appeared, had been paid off by her mother to provide certain types of testimony.
The attorney said that after the Air Force judge learned about the payment after the court-martial but before sentencing, he refused to consider the boyfriend's testimony as tainted. The boyfriend and the ex-wife also denied under oath that they were in a romantic relationship, which would further have tainted the testimony and constitute perjury, he said.
At trial, the ex-wife denied that she had had a relationship with this new gentleman, and the judge didn't allow any sort of questioning about her motive to lie in order to be with the new guy. The trial judge would refuse to hear that information, but it would have substantially changed the assessment of credibility, where we have information that she was trying to protect a new relationship.
In the limited questioning that was allowed of the ex-wife and her boyfriend, the two gave contradictory accounts of the timeline of their relationship and the nature of the payment. Anderson's suit petitions the federal civilian court to take into account these facts and the Air Force's refusal to consider them material. Anderson said the battle for him now is to reclaim his reputation and to speak out against the Obama-era culture inside the military's legal system that continues to subvert due process for politics. Neil W. McCabe, One American News, Washington.
Want to see more videos like this? Click on the link below and subscribe to One American News on YouTube, and call your cable provider and kindly demand that One American News is added to your lineup. Call and subscribe today.